jurisdiction to hear the election petition. I believe that is a civil matter. Quasi civil but it's a civil matter, presidential election. And the next one, there is the advisory opinion, which is civil jurisdiction. We have the appeals from the Court of Appeal and tribunals. I have not seen an appeal from the tribunals going directly to the Supreme Court, but there is the jurisdiction to deal with appeals directly when they deal with constitutional interpretation. If it's a matter dealt with by the Court of Appeal involving interpretation of the Constitution, an appeal lies as of right to the Supreme Court. On the other aspects of the jurisdiction, it's a matter of public interest, and I think the Supreme Court has dealt with that.
Just on that small issue, you said public interest. I think the word used there is of general public importance. What to you is the difference between a matter of public interest and general public importance, and how would you distinguish the two?
Public interest can be compartmentalized. You can dissect it, because you can have NGOs coming in the name of public interest, but they are serving their own sectional interests. General public importance is wider. It covers, as you read this issue, it seems to be affecting the general public, like BBI. If an issue is presented before the Supreme Court relating to BBI, having come all the way from the High Court to the Court of Appeal, it will be a matter of general public importance. So to me, public interest is compared to general public importance.
And what is the test? What is the test in your view? How would you do? Because that is where the meat of the Supreme Court jurisdiction is, vis-a-vis the Court of Appeal. How would you distinguish the two?
The short answer to that will be to all depend on the issue itself and the objective interpretation of the court, because I cannot perceive an issue and say this is general public importance. For instance, if it's a nationwide issue which is the concern of the general public, like I'll give an example, like if an issue, somebody was to say Kenya should no longer borrow from the IMF or from whoever, and goes to the Constitutional Court, and an appeal is taken to the Court of Appeal, that is a matter of general public importance. That is
so any cases that come to mind?
I'm giving because there isn't. I'm giving an example that
I mean, because what I want to know is the test, because part of the complaint you will hear out there is that the Supreme Court came to solve all our problems, isn't it? That why do we have a Supreme Court yet it is not hearing our issues? So 164 has said no, we are not dealing with everything. We are dealing with issues of general public importance as opposed to public interest. So one of the things you will be dealing with on everyday basis is how do we distinguish these two streams? But this one, go home, it is public interest but not general public importance. And this one may be of general public importance, but the public has no interest.
There is no one answer to that. I will lie to you to say this group of cases belong to general public importance, and this one, because it's initiated by lawyers or by an NGO, it's a matter of public interest. Okay. It will all depend. My answer is this. Honestly, it will all depend on the problem itself.
Okay. There are many decisions of the Supreme Court on that. Next question, and just as I'm finalizing on this aspect, one of the issues that concerned me when you were starting and this goes, you've talked about a backlog and dealing with backlog, and thank you for exposing some of the problems we face. One of the issues you said that which I caught is that you worked yourself to the extent of becoming a diabetic. Now my concern is this, room 17, you're holding 5 hearts. What fear should I fear that those 5 hearts will cause you to aggravate your diabetes? And what is it you will do to avoid this kind of situation?
Okay, I think the bigger problem is the induction. When you are inducted, that time you are not warned against overworking yourself, and that is a bigger problem. I think some of the committees came up with the issue that newly recruited staff should be inducted. I'll give you an example. On a Thursday when I had confirmation of grants, I would sit from 9 to 3 without even taking a break. I have learnt my way in the judiciary that you need to take a break after maybe 2 hours. And the many hearts, these many hearts will not come when I'm just seated in the office doing the work of many hearts. You'll have to go out, interact, you have to come for a meeting and deliberate on issues, and so it's not an issue that one has to do this work whether you are diabetic or not, whether you are epileptic or not. Those are conditions which are there, but I've learned from the hard way how to handle these many hearts. That time I think I was overworking myself, no exercise from the office, to go and sit and write judgments up to maybe midnight in the morning. You wake up by 5, you're on your day. Okay. Definitely you'll be sick.
Thank you. And finally, I think in one of the papers today, and since this COVID started, the issue of domestic violence has gained a lot of prominence. What do you see is the role of the CJ dealing with the problem of domestic violence?
Okay, the domestic violence, I believe, is related to the family, not mainly husband and wife. Even children are affected by this violence. It's not a Chief Justice only problem, because those involved have to be arrested and prosecuted and the cases fast-tracked, so that if one is convicted, it can send messages to those who are involved. There are already cases in court, people chopped off their hands and convicted. So the role of the judiciary and also of the CJ will be to ensure that whoever is implicated in this is prosecuted. But I'll have another angle to this.
Let me just ask, is there any of the hats you're wearing that focuses on this particular issue?
Yes, there is the hat of being the head of judiciary, and the hat of National Administration, Council of Administration of Justice, where other sectors in the criminal justice or the justice systems are involved. It can be discussed there. The CUCs, that's where I was heading. Sometimes you can see prevalence of an aspect of criminal law, and you go out and educate the people. I remember we used to have so many out talks in Kakamega in conjunction with the county government. Cases of forest, people being charged with taking wood from the forest, will go near the forest and talk to them. The implication, the cases will reduce. So if, as the chair of the National Council on Administration of Justice, we can rope in the prison rope in the DPP and sort of sensitize the public that domestic violence is becoming rampant, and we should know how to deal with it. I think the CJ has a role there to play.
And finally, in terms of case, that same issue, what do you think, the same issue of domestic violence, now we have the COVID situation, we have operations of the courts have been affected. What kind of interventions would you look towards enhancing access to justice in that particular sphere?
We have had COVID, the courts are working, those arrested are taken to court. I know the prisons have been a bit hesitant to take suspects up to open court. We have technology. So as the CJ, I will try as much as possible to ensure that it has worked. All what we can do is to enhance the technology. It has worked. A plea can be taken from the prison as one sits in court, and the prosecutor is in his office. So it's not that we will relax. We will ensure that technology takes over and these cases are heard.
Thank you, my lord. Thank you, Chair.
Thank you, Judge. We are going well. Judge, you can have a sip of water. It's 2 hours. I will now request Honorable Commissioner Macharia Njeru to ask you some questions, and then after that you have Honorable Commissioner Evelyn Olwade to ask you further questions. Thank you.
Okay, thank you, Chair. My Lord, now let us start on this issue of jurisprudence and your legal philosophy. Now, I read this decision that you made on the Council of Imams and Preachers of Kenya in Malindi, where you were clear that a child cannot be married off because that would not be in line with the Constitution. You extensively made reference to the Constitution. Now, my first question would be that why I took interest in it, the fact that you are a Muslim yourself. Now, how do you handle matters that where your Islamic faith may necessarily not agree with the strict legal provisions of the law? How do you balance that out as you are applying the law, even as maybe sometimes it may conflict between your religion and what the law states?
I think the Constitution is clear that there is no state religion, so that's the starting point. So when it comes to making decisions, they should be purely based on the law. I'm sure there are certain aspects of the law when they will be brought to you, and you can see that on the one hand the religion allows, on the other hand the law says this. That was one aspect, and even at the back of my mind I knew that those people who filed that case knew that I'm a Muslim, so let's go to this Muslim brother of ours and terminate this criminal case, because he will understand that from time immemorial under the Islamic faith, a girl of 16 years can be married off. But my view is, first and foremost, you look at the law, and those who married off the 16-year-old girl knew that they are living in Kenya. In fact, I explained that when you are living in a country with the laws, the law comes first, then the religion will follow. It's not that you are being restricted. You know, there are those issues like a law is passed, don't pray. That will not be below, because it will be contrary to the Constitution. The Constitution acknowledges the freedom of conscience. So no law will be passed that don't go for your Friday prayer. But when now these are purely personal aspects of saying a girl of 16 years can be married, I am a Muslim, it's true. In other countries where they don't have certain laws like Kenya, where the marriageable age is 18, they exercise it, but I will go for the law, because if you go contrary to that, you will be setting a precedent that Muslims in Kenya can marry at 16, and I don't think that is the intention of the law.
Okay, thank you, Honorable Judge. Now, then that brings me to the second question of the issues of judicial activism, where there will always be a conflict between the three arms of government, each saying that this is my responsibility. And I want to specifically come now to the issue of legislature, because this is something that keeps arising, where the legislature will say that it's our responsibility to pass the laws, just like you've indicated. Then on the other hand, you find a party who comes and challenges that law, and now it becomes the responsibility of the judiciary to interpret. Now, oftentimes there is conflict that arises, that this judicial overreach. Now, what guides you as a judge, and what are your views regarding that? Because yes, the legislature sometimes will also overreach themselves in passing the law, but they'll say that we are the people's representatives, that's our responsibility. But again, now if the judge comes to a decision that seems to overturn that law that has been passed, again the legislature will say this judicial overreach. I don't know, what are your views regarding it, and what guides you as a judge, and what to be your role as the leader of the judiciary if you are to become the Chief Justice in dealing with those aspects?
These are not gray areas. They have been with us, and the work of the judiciary is to interpret the laws as they are passed by the legislature, and the main focus here is the Constitution. The judiciary will pronounce itself that a certain aspect of the law is unconstitutional. There is, in my view, that is okay, because it's the duty of the judiciary. We can't say that there is the general presumption that all the law passed is in compliance with the Constitution. But when it's analyzed, it's found that it is not, and it is the duty of the judiciary to punch holes to the law which is unconstitutional. However, we have had courts declaring certain aspects of the law as unconstitutional, but they still remain in the laws. I think there is need to come up with an approach. I have also said in the judgment, one of the judgments Commissioner Majanja referred to, one judge will say this is unconstitutional, another judge says it's not, like in the aspect of Section 40 of the County Government Act. So, what should the legislature say? Should they follow the one who says it's unconstitutional, or should they follow this? It is constitutional. So there is also need to come up with areas with the improvement on this declaration of unconstitutionality. It is true this is a conflict. It's not an overreach. I will not call it as an overreach. It's a responsibility, because the judiciary is there to interpret the law. But there is that need of finality, so that actually when we say this section of the law is unconstitutional, in my view, there should be an automatic picking of that declaration by another superior court, so that it can consistently be held to be so, so that I, as a single judge, does not say that a section of the law is unconstitutional. It's left like that. Parties refuse to comply with that, yet maybe on appeal it would have been overturned. So there is it's becoming a bit confusing, and also the Parliament might wish that why can't this aspect be cascaded to another court, so that there is that finality that actually this is unconstitutional. It's true, you can say there should be finality in litigation, but when it comes to declaring law which has been passed by over 200 legislators, I sit there as a single judge. It's true, I'm the expert in interpretation. I say so. Maybe three wise men would rule otherwise. There is need to manage this aspect.
Okay. Now, coming to that issue that you just mentioned, where you have different judges coming to different conclusions, or even sometimes, and this is something that I've seen as a practitioner, for instance, in a employment court, where you find a decision has been made by a court of appeal clarifying a position, but still the employment court goes ahead and goes contrary to it. Now, I wonder, as a Chief Justice, in as much as it is not your responsibility to interfere with the decisional independence of the judges, but for purpose of enhancing kind of uniformity, or where this certainty, as is being said time and again, I don't know what steps you take as the leader of the institution to guide that that process of creating certainty, where different judges are not making different decisions over the same issue, or Court of Appeal has pronounced itself, then you find judges are going against it, or Supreme Court has pronounced itself, then others are going against. I do not know what steps you take. Clear steps.
Okay, thank you, Commissioner. As the head of the judiciary, because these things come to the limelight, they are not secret. We normally have the yearly colloquium where we discuss emerging jurisprudence. We invite one of us to discuss. So, first and foremost, to disobey what the Supreme Court has said, yet the law requires that all superior courts be bound by the decision of the Supreme Court, will be now to dwell on, cannot say impunity, but dwelling on something else. Equally, to disobey what the Court of Appeal has said as a High Court judge, and to say these judges, let me continue saying what I've been saying. would also be to ignore the issue of judicial precedents and the hierarchy of courts, because why did this party appeal to the Court of Appeal? So to solve these problems, it needs first and foremost to bring together, like if we can have a colloquium of the Employment and Labor Relation Court, and you tell them that you are creating confusion in the jurisprudence relating to this aspect of the law, and we deliberate on it and tell them that the Court of Appeal has guided you, so can you follow what the Court of Appeal is saying? Because it's not a matter of you can have your own personal views, but it is a requirement that you respect a higher court. So I would be engaging all the judicial officers, because the magistrates are ready to embrace what the High Court has said. Why can't the High Court and courts of equal status embrace what the Court of Appeal has said? And why can't the Court of Appeal embrace what the Supreme Court has said? So I would, we will now come, we can even have a catalogue of conflict areas. There are even conflicts in the Court of Appeal. I've seen, as I was in Meru, there is the issue of under the Wildlife Act, if you are attacked by a buffalo, that act provides for a system where you start from a committee at the district level, but that process is not working, so people are going directly to the court, and there is a decision by the Court of Appeal saying you should start from that lower court, lower tribunal or committee, and there is another decision saying you can go directly to court. So these are issues of conflict of application of the law, and they can only be harmonized. Maybe like if it was a 3-judge bench of the Court of Appeal, if another issue arises, I would discuss with the president of that court to have a 5-judge bench, which can be seen to be more balanced and more pronounced, and rectify the situation. So I do agree that those instances are there, and it is for the judiciary itself and not somebody from outside to sort this one out.
Now, let us come now to your papers themselves, your qualifications. I saw you have an MBA. Now, tell me, and there's a reason why that will come out from my subsequent questions. How do you think this qualification would be useful in the institution if you are to become the Chief Justice?
Okay, I will answer that from my personal perspective. I took that MBA 1 year after I joined the NSSF, and I could see that we are dealing with finances, we are dealing with HR, we are dealing with ICT, and I have come with a background of the law. You sit in an investment committee where people are talking, investing in shares, investing in real estate, and you are there. All what you can say is you are giving legal advice. So the MBA becomes handy when it comes to dealing with issues to do with HR. It becomes handy to understand information from PMMU. It helps when you have to analyze the data. Like if I receive the DCRT of Commissioner Majanja, what has he been doing for the last 1 month? MBA enables you to analyze his data, how many rulings, how many judgments, how many witnesses have been heard. That is the simplistic aspect of it. MBA also gives you decision-making processes and how to make your decision, analytical aspect of your work area. So it is a cross-cutting. Even the issue of I've been asked, how will you bring under the human resource management, things have to grind the way justice grinds slowly. You can accelerate, but if you are to move faster, you will break, because if you become dictatorial, people will rebel against you. So the tenets of leadership are there under MBA, and I think it is a worthy cause for we lawyers to take, so that you know how to deal with people, you know how to deal with financial situations. I know as lawyers we do accounting at the law school, but that is basic.
Okay. Now with that MBA, I want to come out to the real issues that lawyers particularly encounter every single day in the judiciary. Let me start with the issue of automation, the digital platform that the judiciary is using. Now, I don't know what is your view regarding it, because whereas there's Zoom hearings, there could be Microsoft Teams hearings, and all that, but when it comes to interacting with the system, for many lawyers, it goes beyond that. There's the e-filing, for instance, which is difficult. There are always, every single day I can tell you that the complaints I receive are so many. I'm always, exchanging those complaints with the institution of the judiciary on behalf of lawyers. They can't even sometimes print a receipt. They can't be able to file their documents. The system is down, and of course, the hearing is not just the hearing online, between the judge or magistrate and the lawyer. There's also the aspect of documentation, and it seems not to be working. So I do not know what is your experience regarding the complaints in that aspect, and what you do to truly, digitize the institution, and not to equate online hearings with actual digitization of the systems within the institution. What steps would you take, using your MBA, knowledge?
Okay, I have to be the same people who should go to firefight. They're saying they're not enough, and we need to invest in this so that we can have an expanded band. I think that's the word. The band is not big enough to accommodate many users at the same time. When every judge is there from 9 to midday, there is a lot of interruptions up and down. So the problem is known, and the ICT people are working on it, but there is need for the judiciary to recruit more ICT staff and expand the bandwidth. It's expensive, because I've talked to them. They have that little knowledge. I can't say I'm an ICT expert, but they're saying even we are working at the mercy of international companies like Google, because when you have to go to Safaricom to allow you to use their bandwidth, you will be charged a lot of money. So that's why even the licenses, after every year, our licenses expire, because we are using the ones given freely by companies like Google, so that we can minimize on cost. So there is need to deal with this problem of ICT, because in fact it has changed the work format. Mentions, why do you have to drive from city center to Mili to mention a matter? It can be mentioned online. An appeal where parties have filed submissions and they want to highlight. Why do I need can be real and compared to physical hearings, mainly in those those aspects of the law where we can easily say an appeal can be heard. It's 20 minutes each. I will hear you. I have your submissions, and the system should remain. Because going back to the NBA, when you do NBA, I think you also do the would sit down with the ICT department, get down the requirements to improve on this. I know some of the requirements is that they are shortchanged. In fact, one of them told me that to procure an ICT thing takes a long time. The procurement process is very long, and the judiciary needs to ring-fence the money, the money which has been budgeted for ICT, because by the time the procurement comes through, this money has been used by other departments because we are thin in resources. So they're saying it becomes a problem, and if you wait for next year, maybe that technology has changed. Now we have a new type of machine which has to be, the one you are buying has become obsolete or needs improvement. So as the head of the judiciary, maybe I will ensure that whatever is budgeted for ICT, because it's becoming an important enabler of justice, is used within the ICT. I would even rather put off the construction of a court and expand on what ICT can do, so that it's not becoming, as we said, it was to enable us access justice, but now it's limiting to some extent. We want to reach where we wanted to go.
Yeah, because as you said, there's a significant number of lawyers who feel that the system actually is now becoming an impediment to access to justice. Now, burden of proof, because it's one thing to say that you'd be able to do all that in terms of providing leadership in that. Now, what is it that in your experience, when you look back at your background, because again I've checked right from when you're an advocate to NSF and all that, what is it in your background would make us believe that you've acquired these skills where you can be able to ensure that you're able to oversee the implementation of an efficient digital platform that serves the institution and of course the public at large?
I believe I should restrict myself to digitization, not to the wider aspect of the leadership.
Yeah, the digitization.
Okay, from my background, when you are a practitioner, our times there wasn't a lot of digitization. You have your computer in the office and you use it to produce your pleadings and do your internal office management. I interacted with this ICT when I was at NSSF, and it's expensive. You have to buy systems which will enable each branch to log in and see the processes of the institution, working on the benefits of the retirees. Coming to the judiciary now, we have talked about ICT for long, to the extent that now it is becoming monotonous. ICT. The JTF, one of the pillars is ICT. They did their best, acquired, established the ICT department or directorate. SJT has come up with digitization as one of the pillars of SJT. So the totality, the burden of proof, which is the answer, is I know how ICT can improve the workplace. I know for sure it can. And the only solution to this is to talk to these people who are working on it. I remember at NSSF would spend millions, but when the instrument is bought, it doesn't work. You would go back to buy another one. So it can be an exercise in futility if you get it wrong. The beauty with the judiciary is it is homegrown, and but we need to buy certain aspect of these ICT instruments and cooperate with the ministry, and we will be there. I don't have to say that 100% when you take me, if you take me as the CJ, I will make sure that ICT will work in 100 days. You will be able to not to see these ups and downs. It boils down to the same thing. You have to make people agree that they are here to serve the wananchi, and they should do their best and improve on what is existing now.
Okay, I have three more questions. One, now you mentioned about the issue of backlog and sometimes delays in the writing of judgments and all that, and I want to tie this to the issue of leadership generally. And you actually even said that to deliver judgments within this time, and many of them still didn't. Now, I'm just wondering, what is it that you do as a Chief Justice to make sure that when you do a communication, it is not in vain? It is a communication that will be followed through to, with a view to ensuring that those judgments are indeed delivered, and if they are not delivered, that there are also consequences. Because again, if it's just an idle threat, or a communication that is no follow-up, or there is no implementation in terms of ensuring it's it's indeed followed to the letter, it's of no value. Now, what is it that you do as a Chief Justice to ensure that when there's a communication, when there's a directive, alive also to the fact that you are dealing with people who have security of tenure, they have their rights, but at the end of the day, again, there's the delivery of justice expeditiously?
My long-held principle is that you should justify The CJ Emeritus was very emphatic on this. He didn't issue mere demands and went to sleep. He would even follow it up for those who have not complied. He would follow it up, and he will even calling them, have you complied with this? I remember the office of the DCJ, where the ombudsperson is currently entrenched, would make a demand that can you comply with the letter by the CJ. So we'll put everybody on his toes when it comes to this issue of delayed judgments, when it comes to this issue of backlog, because backlog creates perception of corruption. That is for sure. Even you, if you have and bribe your way at the registry for you to get a hearing date. Commissioner Warsame dealt with the delays even in getting hearing date. But I can say we have improved. When we used to practice by March, the diary for the year is closed. You wait for January. But now in many courts you can get hearing dates for July, you can get hearing dates for magistrate courts for August, for even for June. So as the head of judiciary, it will not be a matter of standing on top of room 17 as commissioners referred it to, issuing demands that you have to comply and waiting for compliance, which is not forthcoming. I will be, maybe the main answer to this will be the PMMU, because that DCRT PMMU instrument
beyond the round table discussions, how do you as the Chief Justice ensure that indeed that it doesn't reach a level where JSC now has to deal with it as a complaint, when it could probably also be sorted out administratively?
Yeah, there are many ways we can deal. For instance, let's take an example maybe of a judicial officer who is performing below the average. A human resource will require that first and foremost you know his problems. Is it naturally an issue of laziness and refusal to work, or maybe this judicial officer has some social problems at home? Another issue is to discuss with the judicial officer for him to know, or her to know, that actually you are underperforming and you came here on the promise that you want this job, because it's you who applied to get this job, and comparatively, because you are not working alone, there are 100 of you and the 5 of you seems to be working below average. I would also look at the aspect of maybe what is your specialty. Maybe you have problems dealing with the criminal law and you like to deal with family matters where the turnover, you can sign grants and hear objection proceedings and refer matters to mediation. So it's an all-rounder, but the bottom line is we want to uplift this judicial officer to the same level as the others. And what do we do if it becomes impossible? Even with that stick, you are trying to propel the officer to those levels, but still you are not getting the results. I believe the question leads to that. What do you do? I think that's why we have the JSC here. The CJ does not have the mandate to send anybody home, but the law comes in and say you can be retired in public interest, because now you cannot perform. You are sick. You have told us you are sick. Maybe you take early retirement. Maybe because it can be a disciplinary issue. Because the disciplinary doesn't mean the code of conduct is that you have to work. The idea of the code of conduct is that you have to work. That's why within the certain parameters, and if you are not fulfilling your obligations, then when do you pay you? JSC is paying your salary. I don't think it can be a hopeless case where we are saying